Dear friends, this is your RAPETI SURYANARAYANA advocate from Vizag. In the earlier session, I said about kinds of evidence, oral evidence, documentary evidence. In this session, I would like to discuss with regard to proof of execution of document, which is very much useful and important to all the persons who are appearing for civil exams, civils, and also for junior civil judges, and also for district judges exams, and also to the law students, and also for the practicing advocates. This is very much important to all the persons to prove the execution of document in the court of law. To prove the execution of document, what is required as per Indian Evidence Act? Let us see in this session. The proof of execution of document is one of the part of the documentary evidence in the Indian Evidence Act. Sections 67 to 73 deals with proof of execution of document. Let us discuss with regard to section 67. What the section 67 says: proof of signature or handwriting of the person elicited to and signed or written document produced before the court. That means, what is the proof of signature and handwriting of the person who signed or produced before the court? We have to prove that signature or handwriting is the handwriting of that particular person. That means we have to prove the handwriting of the person to prove the signature or handwriting of the document which was produced before the court. In the simple manner, to prove the signature or handwriting of a document, we have to prove that signature or handwriting is in the handwriting of that particular person as per section 67 of Indian Evidence Act. Let us discuss with regard to section 68. What the section 68 says that proof of execution of document required by law. Proof of execution of document required by law to be attested. That means in this case, the document to be attested, execution of document to be attested as per law. Proof of execution of document required by law to be attested. In these circumstances, what we have to prove? That means to prove the execution of document, at least one attesting witness of the document should come before the court and to give evidence with regard to the execution of document. Why? Because it is the document, as per law, it is required to be attested. So, at least one attesting witness should produce before the court to give evidence with regard to the execution of document. This is about section 68 of Indian Evidence Act. Let us discuss with regard to section 69. If attesting witness not found, then what we have to do? As per section 68 says that at least one attesting witness should be produced before the court to give evidence to prove the execution of document. If that attesting witness is not found, then what we have to do? If the attesting witness is not found, then we have to prove the execution of document by any person who knows or acquainted or says that handwriting or attestation of the attesting witness is of a particular attesting witness which was stated in the or attested in the document, and also the person who knows or acquaints with regard to the signature of the executant should come and give evidence before the court to prove the execution of the document. If the attesting witness not found, simple manner, if the attesting witness not found, we have to prove that handwriting of the attesting witness and also signature of the executant. This is with regard to Section 69 of Indian Evidence Act. Then let us discuss if attesting witness kept witness box and denies the execution or does not recollect the execution of the document before the honorable court, then what we have to do? In the earlier session, I said that if the attesting witness not found, then we can give the evidence of any person who knows handwriting of the attesting witness and signature of the executor. But here, attesting witness is found and produced before the court, but he denies the execution of the document or he does not recollect the execution of the document. Then what we have to do? If he denies or does not recollect the execution of document, then we have to choose other evidence to prove the execution of document. Then what are the other evidence to prove the execution of document here then? That means handwriting expert. We can produce handwriting expert before the honorable court to prove the execution of document, or to produce any person who acquainted with the handwriting or signature of the executant, or to produce any person in whose presence the document signed or written by the executant, or in the similar manner, if the person who signed or wrote the document can come and give the evidence before court. In all these circumstances, we can prove the execution of the document if the attesting witness denies or does not recollect the execution of the document. There are 4 points. The first one is by producing handwriting expert before the honorable court to prove the execution of the document. Next one is by producing any person who is acquainted with the handwriting or signature of the executant. Next, by producing any person in whose presence the document was signed or written by the executant. In all these circumstances, we can prove the execution of document, even though attesting witness denies or does not recollect the execution of the document. Next, this one deals in the section 71 of Indian Evidence Act. Let us discuss with regard to section 70. What the section 70 says that if the party to the execution of the document is admitted, then what will happen? If the party to the execution of document is admitted, then it is sufficient to prove the execution of document against him, even though it is required by law to be attested, need not produce at least one attesting witness before the Honorable Court to prove the execution of the document. Why? Because here the party itself admitted the execution of the document. That is sufficient to prove the execution of document before the Honorable Court. Next, if document is not required by law to be attested, then in what way the proof of execution of document can be proved? The proof of execution of document can be proved if it is not required by law to be attested. Then it can be proved by any one of means as the document as unattested. Only with regard to attested documents only, at least one attesting witness is required to give evidence to prove the execution of the document. But whereas in case of unattested requirement as per law to the documents, no attesting witness can come and give evidence before the Honorable Court. Why? Because the attestation is not necessary as per the law. So it can be proved as unattested document as itself. This one is stated in the section 672 of Indian Evidence Act. Section 67 says that proof of signature and handwriting, whereas section 73 says that comparison of signature and handwriting with admitted or proved signed or written document. That means the court has a power to compare the signature or handwriting with other admitted or proved signature or handwriting. That means the court has power to compare admitted or proved signature or handwriting with other disputed signature or handwriting to come to the conclusion and to determine the issue. This is about with regard to proof of execution of document. In a detailed manner, simply I say that if document is a registered document, to prove the registered document, at least one attesting witness Is it necessary to give evidence? No. If the document is a registered document, no one of attesting witness can give evidence to prove the execution of document. Why? Because it is a registered document under the provisions of Indian Registration Act. If the executant of that registered document denies the execution of that registered documents, then what we have to do? I said that to prove the execution of the document, to prove the execution of the registered document, which was registered as per the Indian Evidence Act, the attesting witness did not come before the court to give evidence with regard to execution of the registered document. But if the executant denies the execution of the registered document, then what we have to do? Then at least one attesting witness should give before the Honorable Court to prove the execution of the registered document. With regard to wills, to prove the execution of the will, what we have to do? To prove the execution of the will, the person who executes the wills, that is nothing but known as attestor, testator. The person who executes the wills is nothing but known as testator. This testator, even though he admits the execution of the will by him, that is not sufficient to prove the execution of the will. At least one attesting witness of that particular will should give evidence to prove the execution of the will. That means, to prove the execution of the will, testator as well as at least one attesting witness of that will should give evidence before the court to prove the execution of the will. Here I covered about with regard to registered documents, wills. Now let us discuss with regard to electronic signature. To prove the electronic signature, what we have to do? That means, to prove the electronic signature affixed to the electronic record, what we have to do? That means, we have to prove that that particular electronic signature is the signature of the subscriber affixed to the electronic record. This one states in section 67A of Indian Evidence Act. Next, if to verify the electronic signature, what we have to do? What is the proof as to verification of the electronic signature? We can prove with regard to the verification of electronic signature by producing electronic signature certificate before the court. That means, to the proof as to the verification of electronic signature, the court directs the electronic certifying authority to produce electronic signature certificate. Next, and also the court has power to direct any person the court has also power to direct any person to apply key listed in electronic signature certificate and to verify the electronic signature is of that particular person affixed to the electronic record. That means by producing electronic signature certificate and by applying for public key and we can verify in the list of the electronic signature certificate that particular electronic signature is of that particular person who affixed it to the electronic record. This is about with regard to proof of execution of documents. In this session, I hope that it is all clear to you all. The proof of execution of document is very much useful to all the practicing advocates. In the earlier class, I said that with regard to proof of contents of documents, the proof of contents of documents can be proved either by primary evidence or by secondary evidence. Whereas in this, the proof of execution of document, there I said with regard to proof of contents of documents. The proof of contents of documents can be proved by primary or secondary evidence. Whereas in this case, proof of execution of document. The proof of execution of document can be proved in all these circumstances. Thanks a lot. Kindly like my videos and subscribe my channel. Thanks a lot.